Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. The enactment of the Medical Marijuana Act has generated a lot of questions and concerns about the status of marijuana, not just medical marijuana. Will it continue to be a crime to possess non-medical marijuana in Pennsylvania? Well, the Superior Court, in a case called Commonwealth v. Jesse, has ruled that marijuana is still a controlled substance and is thus it's still illegal to possess, except if it's medical marijuana consumed or possessed in compliance with the Medical Marijuana Act. It held in this case that the Medical Marijuana Act does not remove marijuana as a Schedule I controlled substance. Here's how the case got to the Superior Court. An Allegheny County resident was convicted of possession of marijuana and drug paraphernalia and sentenced to 2 years probation. This had nothing to do with medical marijuana. This was just a regular marijuana charge and conviction. But he filed a rather creative appeal. He was pro se in his appeal, meaning he represented himself, did not have a lawyer. So you can see kind of the common sense arguments that he makes. However, we'll see how the court treated those arguments. Before the Superior Court, he argued the government's conviction of him for possessing marijuana, and thus violating the Drug, Device, and Cosmetic Act, violated his right to equal protection of the law as guaranteed by the Constitution. He claimed that the enactment into law of the Medical Marijuana Act, which legalizes the consumption of medical marijuana for certain medical purposes, means marijuana is now accepted for its medicinal or medical value, and thus it's no longer or should no longer be a controlled substance because it no longer fits within the definition of Schedule I of the controlled substances under the Controlled Substances Act. Marijuana is a Schedule I drug, and the Controlled Substances Act defines Schedule I drugs as having a high potential for abuse, no currently accepted medical use in the U.S., and a lack of accepted safety for use under medical supervision. And the defendant, who is the appellant, is arguing, wait a second, medical marijuana has an accepted medical use in the USA, and it can be utilized safely under medical supervision. So he's looking at the elements of Schedule I and saying marijuana doesn't really apply anymore because of the Medical Marijuana Act. Now, the Pennsylvania Superior Court disagreed with this common sense argument. It stated the Medical Marijuana Act does not declare that marijuana is safe and effective for medical use. Instead, in the text of the Act, it uses words such as concerning medical use, safe and effective for medical use. It uses words such as suggests, potential, and may. And as such, it doesn't conclusively demonstrate that the General Assembly found marijuana to have an accepted medical use, other than, according to the Superior Court, for its palliative or analgesic effects. So I guess the Superior Court doesn't think that those effects are for medical use, which is not quite copacetic with what medical use is. Furthermore, the court explained that the temporary nature of the Medical Marijuana Act serves as an acknowledgement that the General Assembly wants more research to be done into the medical value. The court held that the two statutes, the Controlled Substance Act, which makes marijuana a Schedule I drug and thus illegal, and the Medical Marijuana Act, which permits medical marijuana to be consumed, possessed within the confines of the Act, are in harmony and not in conflict, contrary to the argument made by the defendant in the case. So the Superior Court affirmed the trial court's conviction of this person for possession of marijuana. The Medical Marijuana Act does not override the Drug, Device, and Cosmetic Act. Marijuana is still a controlled substance, a Schedule I drug, and it's still illegal to possess it unless it's medical marijuana possessed pursuant to the strict terms of the Medical Marijuana Act. Well, that's all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. If you have any questions about medical marijuana or are involved in a case involving a controlled substance, you're welcome to contact the attorneys at Scaringi Law at 717-657-7770. Thanks for listening, and enjoy your lunch.